All right, welcome. We're about to tackle a really crucial chapter for your LSO paralegal exam. We're going to break down the key principles, the rules you have to know, and of course, the traps to watch out for so you can handle any question on this topic with confidence.
Okay, so let's dive right in. We've set this up to work just like you'll think on the exam. We'll start by spotting the issue in a question and then walk all the way through to locking in the right answer. Let's get to it.
First up, the big picture. Before we get into all the nitty-gritty details, we really need to understand why the Law Society thinks this is so essential, not just for you to pass this exam, but for your entire career as a paralegal.
So, what's this chapter all about? Well, at its heart, it gives you the legal and historical backstory of the relationship between Indigenous peoples and the Crown. But look, this isn't just some history lesson. It's about understanding a whole legal framework that is absolutely foundational to Canadian law.
And here is the single most important reason to pay attention, especially for your exam prep. These ideas, they don't just stay in their own little box. You're going to see them pop up in questions across a bunch of different subjects: professional responsibility, constitutional law, you name it. So, mastering this chapter means you're picking up easy marks all over the exam.
Next up, let's talk about triggers. Think of these as the specific words or scenarios in an exam question that should immediately make a light bulb go off in your head, signaling, aha, this is a Chapter 15 issue. It's all about pattern recognition.
Okay, so you're reading a fact pattern, and you see anything about land, resources, traditional practices, or hunting grounds. Your brain should instantly go to Aboriginal and treaty rights. And the key you're looking for? That's going to be Section 35 of the Constitution Act 1982.
Now, what if you get a question about how a First Nation governs itself? Say, how it chooses its chief and council. That's your trigger to remember that there isn't just one answer. It's a system with options. It could be the Indian Act, it could be a modern self-government agreement, or it could be based on the band's own customs.
And finally, if a scenario mentions a survivor of a historical injustice like the residential school system, well, that's a direct signal from the people who wrote the exam. They are testing your understanding of your professional duties and whether you know how to apply the principles of trauma-informed practice.
All right, let's get to the heart of it. This is the stuff you absolutely positively have to know cold for exam day. These are the non-negotiables.
I really like this slide because it gives you a kind of mental map of the whole relationship. You can see the evolution, right, from separate worlds to making treaties as nations, then into that really dark period of assimilation under things like the Indian Act, and now into our modern era of renewal and hopefully reconciliation. This timeline gives context to basically every legal rule we're going to talk about.
This is a simple but super important definition right from Section 35. When the Constitution talks about the Aboriginal peoples of Canada, it specifically means three distinct groups: First Nations, Inuit, and Métis. They all have their own unique histories and cultures, but they share this constitutional protection. The key for the exam: don't mix them up.
Okay, this breaks down the two constitutional pillars you have to know. Section 9124 is all about power. It gives the federal government the authority or jurisdiction. Section 35, on the other hand, is about rights. It recognizes and affirms rights that already existed. Power versus rights. You have to know the difference.
Hey, remember that trigger we talked about? The one about governance? Well, here's a checklist. If you get a question about how a First Nations leadership is chosen, the answer is going to be one of these four pathways. You just need to know that these different options exist.
So these are the big ideas from the Supreme Court that pretty much guide everything in this area of law. It all starts with the honor of the Crown, this idea that the government has to act with integrity, and out of that flows the duty to consult. And where is it all heading? Towards one main goal: reconciliation. These principles are the lens through which every treaty and right is interpreted.
Okay, let's talk about the tricky stuff, the nuance. You see, the easiest way for an exam to test you is not on the big general rule, but on the exceptions to that rule. This is really where you can stand out and grab those extra marks.
So here's a huge one. Section 35 rights are incredibly powerful, but, and this is a big but, they aren't absolute. The Supreme Court came up with something called the Sparrow Test, which says the government can infringe on a right, but only if they can prove it's justified. That means they need a good reason, like conservation, and they have to do it in a way that respects the honor of the Crown.
This is another key qualification.
The best way to think about Section 25 of the Charter is like a shield. Its job is to make sure that the collective, group-based rights of Indigenous peoples aren't wiped out by a challenge based on an individual's charter rights. It literally shields the collective from the individual.
Let's move on to the traps. These are the things that sound similar or are easily confused, and they are perfect for creating those tricky, plausible but wrong answer choices on a multiple-choice exam. First up, the doctrine of discovery and terra nullius. Now, you need to know what these old colonial ideas are, but what's way more important is that you know they have been completely and totally rejected by Canadian courts. They have no legal basis. So if you see them on the exam, they're there as a distractor. They are the wrong answer.
This is a big one. You have to know the difference between the duty to consult and free, prior, and informed consent. Here's the bottom line. The duty to consult is the current legally binding law in Canada today. Free, prior, and informed consent, or FPIC, is an international standard that Canada is working towards. So think of it as what the law is now versus where the law is going. Don't get them mixed up.
Finally, let's bring it all home. What's the bottom line? What are the real-world, practical results of all this that you need to know for your exam and, of course, for your practice?
These are the direct results of this big shift towards reconciliation. You've got the TRC's 94 calls to action, which are basically a roadmap, and number 27 is aimed directly at legal professionals like us. We've got UNDRP being written into Canadian law, and we're seeing brand new laws that actually affirm Indigenous control over key areas like child welfare.
This quote from the TRC just says it all, doesn't it? Reconciliation isn't a single event you can check off a list. It's an ongoing process. It's about building and then maintaining a new, respectful relationship. That's the principle that guides this entire movement.
And that brings us to our last thought. This stuff isn't just about passing your exam. It's about understanding that you're about to enter a legal system that is fundamentally evolving. This ongoing process of braiding Indigenous legal traditions with Canadian law is going to shape the very nature of justice in this country for your entire career.